An important issue concerning this entire matter is whether or not proper name, perverted into a all caps assemblage of letters, can be substituted for a lawful Christian name or any proper name, such of or as the state of Florida, uppercase, lowercase, proper noun. Is the assertion of the all capital letters name legal? If so, from where and whence does this practice originate, and what enforces it? A legal fiction may be employed when the name of a person is not known, and therefore using the fictitious name John Doe as a tentative or interim artifice to surmount the absence of a true knowledge until the true name is known. Upon discovering the identity of the fictitious name, the true name replaces it. In all cases, a legal fiction is an assumption of purported fact, without having shown the fact to be true or valid. It is an acceptance with no proof. Simply to assume is to pretend. Orrin's Dictionary of Law says the word assume means to take up or take responsibility for, to receive, to undertake, see assumption, to pretend, to accept without proof. These same basic definitions are used by nearly all of the modern law dictionaries. It should be noted that there is a difference between the meaning of a second and third definition with that of the first. Pretending and accepting without proof are of the same understanding and meaning. However, to take responsibility for and receive or assumption does not have the same meaning. Orrin's definition assumption as formally transforming someone else's debt into your own debt. Compare with guarantee. The assumption of a mortgage usually invokes taking over the seller's mortgage debt when buying a property, often a house. Now, what happens if all the meanings for the words assume are combined? In a literal and definitive sense, the meaning of assume would be the pretend acceptance without proof that someone has taken responsibility for, has guaranteed, or has received a debt. Therefore, if we apply all this in defining a legal fiction, the use of a legal fiction is an assumption or pretension that the legal fiction named has received and is responsible for a debt of some sort. Use of the legal fiction John P. Jones, all capital letters, in place of the proper name John Paul Jones implies an assumed debt guarantee without any offer of proof. The danger behind this is that if such an unproven assumption is made, unless the assumption is proven wrong, it is considered valid. As an assumed debt is valid unless proven otherwise. An unrebutted affidavit, claim, or charge stands as the truth in commerce. This is in accordance with the Uniform Commercial Code, valid in every state and made a part of the statutes of each state. A name written in all caps resembling a proper name but grammatically not a proper name is being held as a debtor for an assumed debt. Did the parties to the complaint incur that debt? If so, how and when? Where is the contract of indebtedness that was signed and the proof of default thereon? What happens if the proper name, i.e., John Paul Jones, uppercase, lowercase, indicating a proper noun, answers for or assumes the fabricated name, i.e., John P. Jones, all capital letters? The two become one and the same under the doctrine of idiom sonum. Thus, this is the crux for the use of the all caps name by the U.S. government and the states. It is the way that they can bring someone into the de facto venue and jurisdiction that they have created. By implication of definition, this also is for the purposes of some manner of assumed debt. Why won't they use the state of Texas, uppercase, lowercase, or John Doe, uppercase, lowercase, in their courts or on a driver's license? What stops them from doing this? Obviously, there is reasons for using the all caps since they are very capable of writing proper names, just as their own official styles manuals state. The reason behind legal fictions is found within the definition cited above. The legalities of the all capital letters name. We would go on for hundreds of pages citing the legal basis behind the creation and use of all capital letters names. In a nutshell, fabricated legal persons, such as State of Texas all capital letters, can be used to fabricate additional legal persons. Fictions arise from the law, not the law from fictions. Bastard legal persons originated from any judicial governmental actors that wish to create them, regardless of whether he, she, it is empowered by law to do so. However, a law can never originate from a fictional foundation that doesn't exist. The generic and organic original U.S. Constitution was validated by treaty between individual nations, states, all of which are artificial corporate entities, since they exist in abstract idea and construct. Contained within it is the required due process of law for all the participating nation states of that treaty. Representatives of the people in each nation state agreed upon and signed it. The federal government is not only created by it, but it is also bound to operate within the guidelines of the constitutional due process. Any purported law that does not originate from constitutional due process is a fictional law without validity. Thus, the true test of any American law is its basis of due process according to the organic U.S. Constitution. Was it created according to the lawful process or created outside of a lawful process? Executive orders and directives. For years, many have researched the lawful basis for creating the all-caps juristic person and have concluded that there is no such foundation according to valid laws and due process. But what about those purported laws that are not valid and have not originated from constitutional due process? There's a very simple answer to the creation of such purported laws that are really not laws at all. Executive orders and directives. They are color of law without being valid laws of due process. These executive orders and directives have the appearance of law and look as if they are laws, but according to due process, they are not laws. Rather, they are laws based on fictional beings and are the inherently defective basis for additional fictional laws and other legal fictions. They are regulated, promulgated, by administrative code, rules, and procedures, not due process of law. Currently, executive orders are enforced through the charade known as the Federal Administrative Procedures Act. Each state has also adopted the same fatally flawed administrative laws. Lincoln established executive orders 85 years after the independence of the United States. 7 southern nation states of America walked out of the second session of the 36th Congress on March 27, 1861. In so doing, the constitutional due process quorum necessary for Congress to vote was lost, and Congress was adjourned sine die, or without a day to reconvene. This meant that there was no lawful quorum to set a specific day and time to reconvene, which, according to Robert's Rules of Order, dissolved Congress. The dissolution automatically took place because there are no provisions within the Constitution allowing the passage of any congressional vote without a quorum of the state. Lincoln's second executive order of April 1861 called Congress back into session days later, but not under the lawful authority or lawful due process of the Constitution. Solely in his capacity as Commander-in-Chief of the U.S. military, Lincoln called Congress into session under authority of martial law. Since April of 1861, Congress has not met based on lawful due process. The current Congress is a legal fiction based on nothing more meritorious than so what are you going to do about it? Having a monopoly on the currency, law, and what passes for government, and most of the world's firepower, the motto of the powers that be is We have got what it takes to take what you've got. Legal fiction laws, such as the Reconstruction Acts and the implementation of the Lieber Code, were instituted by Lincoln soon after and became the basis for the current laws in the U.S. Every purported act in effect today is de facto, based on colorable fictitious entities created arbitrarily out of nothing without verification, lawful foundation, or lawful due process. All of such laws are not law, but rules of rulership by force conquest originating from and existing in military martial law jurisdiction. Military martial law jurisdiction of war, win, lose, interactions consisting of eating or being eaten, living or dying, food chain, law of necessity, suspension of all law other than complete freedom to act in any manner to eat, kill, or destroy, or avoid being eaten, killed, or destroyed, no law, lawlessness, complete absence of all law basis to create any valid law. Contractually, being a victim of those acting on the alleged authority granted by the law of necessity, no lawful object, valuable consideration, free consent of all involved parties, absence of fraud, duress, malice, and undue influence, no bona fide enforceable contract, no valid enforceable nexus, absolute right to engage in any action of any kind in self-defense, complete and total right to disregard any alleged jurisdiction and demand for self-admitted outlaws committing naked criminal aggression without any credibility, and right to demand allegiance and compliance from anyone. Every president of the United States since Lincoln has functioned by executive order issued from a military martial law jurisdiction, with the only law being the law of necessity, i.e., the war powers. The war powers are nothing new. Indeed, they have been operational from the instant the first man thought he would hide from God, tried to cheat ethical and natural law by overreaching and invade the space and territory of others, covet other people's land or property, steal the fruits of their labors, and attempt to succeed in life by win-lose games. All existing authority in the United States today derives exclusively from the war powers. Truman's reaffirmation of operational authority under the war powers begins. Now, therefore, I, Harry S. Truman, President of the United States of America, acting under the and by virtue of the authority vested in me by Section 5B of the Trading with the Enemy Act of October 6, 1917, 40 Statute at Large 415, as amended, Section 5B of Appendix to Title 50, and Section 4 of the Act of March 9th, 1933, 48 Statute at Large 2, sick transit rights, substance, truth, justice, peace, and freedom in America, the land of the free and the home of the brave. The abolition of the English and American common law. Here's an interesting quote from the 1973 session of the U.S. Supreme Court. The American law. In this country, the law in effect in all but a few states until the mid-19th century was the pre-existing English common law. It was not until after the war between the states the legislation began generally to replace the common law, Roe versus Wade. In effect, Lincoln's second executive order abolished the recognized English common law in America and replaced it with laws based on the fictional legal foundation, i.e., executive orders and directives executed under authority of the war powers. Most states still have a reference to the common law within their present-day statutes. For example, in the Florida Statutes, 1999, Title I, Chapter 2 at 2.01, common law and certain statutes declared in force in states. The common and statute laws of England, which are of general and not a local nature, with the exception hereinafter mentioned, down to the 4th day of July 1776, are declared to be of force in this state, provided that the said statutes and common law be not inconsistent with the Constitution and the laws of the United States and the acts of the legislator of this state. History, 1st November 6th, 1829. Note that the basis of the common law is an approved act of the people of Florida by resolution on November 6, 1829, prior to Lincoln's Civil War. Also note that the subsequent laws, as a result of acts of the Florida legislature and the United States, now take priority over the common law in Florida. In April 1861, the American and English common law was abolished and replaced with legal fiction laws, aka statutes, rules, and codes based on executive order and not the due process specified within the organic Constitution, existing and functioning under the law of necessity ab initio. They are all non-law and cannot validly assert jurisdiction, authority, or demand for compliance from anyone. They are entirely rules of rulership, i.e., organized piracy, privilege, plunder, and enslavement, intended and enforced by those who would rule over others by legalized violence in the complete absence of moral authority, adequate knowledge, and natural law mechanisms to accomplish any result other than disruption, conflict, damage, and devastation. The established maximum of law applies. One who exercises jurisdiction out of his territory cannot be obeyed with impunity. Applying it all to current laws. An established maximum of law states the importance of the name. In order rightly to comprehend a thing, inquire first into the names, for a right knowledge of things depends upon their names. Title 3, Pleadings and Motions, Rule 9A, Capacity, Federal State Rules of Civil Procedure states, in pertinent part, when an issue is raised as to the legal existence of a named party or the party's capacity to be sued or the authority of a party to be sued, the party desiring to raise the issue shall do so by specific negative averment, which shall include supporting particulars. Rule 9A, Federal State Rules of Civil Procedure, Title 28, United States Code, Appendix, unstatutory, see statutory, Title I, United States Code, subsection 204 notes. At this juncture, it is clear that the existence of a name written with all caps is a necessity created by legal fiction. This is surely an issue to be raised, and the supporting particulars are outlined within this memorandum. Use of the proper name must be insisted upon as a matter of abatement correction for all parties of an action of purported laws. However, the current courts cannot correct this since they are all based on presumed assumed fictional law and must use artificial juristic names. Instead, they expect the lawful Christian man or woman to accept the all caps name and agree by silence to be treated as if he or she were a fictional entity invented and governed by mortal enemies. They must go to unlimited lengths to deceive and coerce this compliance, or the underlying criminal farce would be exposed and a worldwide plunder enslavement racket that has held all of life on this planet in its vice grip for millennia would crumble and liberate every living thing. At this point, the would-be rulers of the world would be required to succeed in life by honest, productive labors, the way those upon whom they parasitically feed are forced to conduct their lives. Oklahoma statutes. Since the entire game functions on the basis of people's failure to properly rebut a rebuttable presumption, the issue then becomes how to properly rebut their presumption that you are knowingly, intentionally, and voluntarily agreeing to be treated as if you were the all caps name. One angle of approach is found in the requirements for proper names to be identified in any legal dispute. This includes a mandate to correct the legal paperwork involved when proper names are provided. In regard to criminal prosecution, this is clearly set forth in the Oklahoma Statute, Chapter 22, Section 403. When a defendant is indicted or prosecuted by a fictitious or erroneous name, and in any stage of the proceeding his true name is dissolved, it must be inserted in the subsequent proceeding, referring to the fact of his being charged by the name mentioned in the indictment or information. Legal definition. In fact, it would appear that the Oklahoma statutes are saying that the use of the fictitious name in either an indictment or information prosecutorial, that such use is forgivable upon after the fact correction. Unfortunately, that is not the case when held to legal definition. Fictitious names. A counterfeit, alias, finged, or pretend name taken by a person differing in some essential particular from his true name, consisting of a Christian name and patronymic surname, with the implication that it is meant to deceive or mislead. Black's Law Dictionary, 6th edition, page 624. The use of, by implication, mistake, or otherwise, of a fictitious name within any lawful and even legal document renders said document instrument fatally flawed for simple fraud. And since no private citizen can be held accountable for the same crime twice, by guarantee, then if initially one is charged in the wrong name and that mistaken identity at any stage of the proceeding renders the present proceeding null, void, and dismissed, this renders the above statute as null and void, and never written. For this fatal error cannot be corrected, and one must secondly face the same charges. Mistaken identity cannot be used as a correctable error merely because one cannot be charged twice for the same cause, even if the first charge was mistaken. But that is not the limit of legal definition of fictitious use of names. It is much more serious to use a fictitious name as a plaintiff. Fictitious plaintiff. A person appearing in a writ, complaint, or record as a plaintiff in a suit, but who in reality does not exist, or who is ignorant of the suit and of the use of his name in it. It is a contempt of court to sue in the name of a fictitious party. Black's Law, 6th edition, page 624. Obviously, any action in which both and or all parties are fictitious is a fictitious action, and it is legally defined as such. Fictitious action. An action brought for the sole purpose of obtaining the opinion of a court on a point of law, not for the settlement of any actual controversy between the parties. Black's Law, 6th edition, page 624. These three legal definitions have now led us to one final definition that defines any and all such fictitious actions. Fictitious. Founded on a fiction, having the character of a fiction. Pretend, counterfeit, finged, imaginary, not real, false, not genuine, non-existent. Arbitrarily invented and set up to accomplish an ulterior objective. Black's Law, 6th edition, page 624. It does not take a rocket scientist to figure out many of these ulterior objectives: constitutional abrogation, tyranny, despotism, false personation, embezzlement of the public money, banking fraud, commercial fraud, identity theft, neglect of office, malfeasance, misfeasance, and nonfeasance of office, piracy, privateering, kidnapping, false imprisonment, ransoming, constitutional malpractice, maritime fraud, military fraud, trademark infringement, counterfeiting, anti-Christian acts, securities fraud, communism, fascism, alien enemy program, etc. The list is almost endless. It appears thus far that the legal definition of these fictitious, legal, fiction, imaginary, etc., assumptive, presumptive, has far and away been the most damaging reference used to the cause and case of the tyrants and despots that are so prevalent. American jurisprudence. In general, it is essential to identify parties to the court actions properly. If the alleged parties to an action are not precisely identified, then who is involved with whom or what and how? If not properly identified, all corresponding judgments are void, as outlined in Volume 46, American Jurisprudence 2D, at judgment. Subsection 100, parties. A judgment should identify the parties for and against whom it is rendered, with such certainty that it may be readily enforced, and a judgment which does not do so may be regarded as void for uncertainty. Such identification may be achieved by naming the person for and against whom the judgment is rendered. Technical deficiencies in the naming of the person for and against whom judgment is rendered can be corrected if the parties are not prejudiced. A reference in a judgment to a party plainly liable, followed by an omission of the party's name for the language of the decree, at least gives rise to an ambiguity and calling for an inquiry into the court's real intention as reflected in the entire record and surrounding circumstances. Footnote numbers and cites are omitted. The present situation in America. A legal person equals a legal fiction. One of the terms used predominantly by the present civil government and courts in America is legal person. Just what is a legal person? Some definitions are a legal person, a body of persons or an entity as a corporation considered as having many of the rights and responsibilities of a natural person and especially the capacity to sue and be sued. Merriam-Webster's Dictionary of Law, 1996. Person, a human being, a natural person. 2, a corporation, an artificial person. Corporations are treated as persons in many legal situations. Also, the word person includes corporation in most definitions in this dictionary. 3, any other being entitled to sue as a legal entity, a government, an association, a group of trustees, etc. 4, the plural of person is persons, not people. See that word. Oren's Dictionary of Law, West Group, 1999. Person, an entity with legal rights and existence, including the ability to sue and be sued, to sign contracts, to receive gifts, to appear in court, either by themselves or by lawyer, and generally other powers incidental to the full expression of the entity in law. Individuals are persons in law unless they are minors or under some kind of other incapacity, such as court finding of mental incapacity. Many laws give certain powers to persons, which in almost all instances include business organizations that have been formally registered, such as partnerships, corporations, or associations. Duheim's Law Dictionary. Person, noun, person. Latin persona, said to be compounded of per, through or by, and sonus, sound, a Latin word signifying primarily a mask used by actors on the stage. In law, an artificial person is a corporation or body politic. Blackstone, Webster, 1828 dictionary. A sovereign is not a person. United Mine Workers versus United States. A name is word or words used to distinguish and identify a person. Name, 65 Corpus Juris Secundum, subsection 1, page 1. Person, it may include, limited to, artificial beings, as corporations, territorial corporations, foreign corporations relating to taxation and revenue laws. Title 14th Amendment, person. A county, a slave, estate of a decedent, a judge holding court, an infant, ward of the court, officer, partnership, and woman, participant in the forbidden acts, defendant and plaintiff, agents, officers, and members of a board of directors or trustees, or their controlling bodies of corporations. The legal subject matter, or substance, rem or res. Bovier's Law Dictionary, 8th edition, page 2574. A corporation incorporated under the de jure law, i.e., by bona fide express contract between real beings capable of contracting, is a legal fact. Using the juristic artifice of presumption or assumption, a device known as a legal fiction, implied contract, constructive trust, another entirely separate entity can be created using the name of a bona fide corporate legal fact. The name of the corporation by altering the name of the corporation into other corrupted format, such as the all caps letter or abbreviated words in the name. The corporation exists in law, but has arbitrarily been assigned another name. No such corporation, legal fact, nor any valid law, nor even a valid legal fiction can be created under the law of necessity, i.e., under no law. Likewise, the arbitrary use of legal fiction artifice of rights of presumption over unwary, uninformed, and usually blindly trusting people can be legitimately exercised under no law. Anything whatsoever done under alleged authority of naked criminal aggression, i.e., law of necessity, can be rendered legitimate. Maxims of law describing necessity include: necessity has no law. Plowed 18th and 15th VIN ABR 534, 22 ID 540. In time of war, laws are silent. Cicero. Non-existent law, the legal condition that universally prevents, guess I'm on my screen there. That universally prevails in the official system of the world today means that no lawful basis exists upon which anything can be created or be made to transpire, upon which basis allegiance and obedience can be legitimately demanded. Acting under the laws of necessity, i.e., lawlessness, allows complete and total right of everyone to disregard any and all alleged assertions of any law, verifiable and legitimate jurisdiction over anything or anyone. Anyone acting against anyone under such non-law is self-confessing to be a naked criminal aggressor and con man who has forfeited all credibility and right to demand allegiance, obedience, or compliance with any jurisdiction he might assert. If you, as a real being, are in real law and it is impossible for an attorney or judge to recognize or access it, you are not and cannot be made subject to by them in their jurisdiction. The crucial issue is then how to notice them of your position and standing. A person created under a de jure law with the person's identifying name appearing as prescribed by law and according to the rules of English grammar is a legal fact. A corrupted alter ego version of that name manufactured under the legal fiction of right of presumption will have credibility only so long as the presumption remains unchallenged. The rule of the world is that anything and everything skates unless you bust it. Legal or lawful. It is crucial to define the definition between legal and lawful. The generic Constitution referenced genuine law. Genuine law. The present civil authorities and their courts use the word legal. Is there a difference in the meaning? The following is quoted from a dictionary of law of 1893. Lawful, in accordance with the law of the land, according to the law, permitted, sanctioned, or justified by law. Lawful properly implies a thing conformable to, or enjoyed by law. Legal, a thing in the form of or after the manner of law or binding by law. A writ or warrant issuing from any court under the color of law is a legal process, however defective. See legal. Legal, Latin, legalis, pertaining to the understanding, the exposition, the administration, the science, and the practice of law. As the legal profession, legal advice, legal banks, newspapers implied or imputed in law, opposed to actual legal, looks more to the letter, form, appearance of, and lawful to the spirit, substance, content of the law. Legal is more appropriate for conformity to positive rules of law. Lawful for accord with ethical principles. Legal imports rather that the forms appearance of law are observed, that the proceeding is correct in method, that rules prescribed have been obeyed. Lawful, the right that the right is act full in substance, that moral quality is secured. Legal is the antithesis of equitable and the equivalent of constructive. 2 Abbott's Law Dictionary 24. Legal matters, administrative, conform to and follow rules. They are equitable in nature and are implied, presumed, rather than actual express. A legal process can be defective in law. This accords with the previous discussion of legal fictions and color of law. To be legal, a matter does not have to follow the laws. Instead, it conforms to and follows the rules or forms of law. This is why the federal and state rules of civil procedure and criminal procedure are cited in every court petition so as to conform to legal requirements of the specific juristic person named, ergo, state of Georgia, all capital letters, or the U.S. federal government, all capital letters, that rule the courts. Legal lawful matters are ethically enjoined in the law of the land, the law of the people, and are actual in nature, not implied. This is why whatever true law was upheld by the organic constitution has no bearing or authority in the present day legal courts. It is impossible for anyone in authority today to access or even take cognizance of true law, since authority is the law of necessity. Title 12, United States Code 95. Therefore, it would appear that the meaning of the word legal is color of law, a term which Black's Law Dictionary 5th edition defines as color of law, the appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state is action taken under color of law. Black's Law Dictionary 5th edition, page 241. Executive orders rule the land. The current situation is that legalism has usurped and engulfed the law. The administration of legal rules, codes, and statutes now prevails instead of the actual law. This takes place on a federal as well as a state level. Government administrates what it has created through its own purported laws, which are not lawful but merely legal. They are arbitrary constructs existing only because of the actions of the people acting on fictitious self-created authority, i.e. no authority. They are authorized and enforced by legal executive orders. Executive orders are not lawful and never have been. As you read the following, be aware of the words code and administration. Look at the United States Census 2000 reveals that the legal authority for the census comes from Office of Management and Budget, OMB, approval, number 0607-0856. The OMB is part of the Executive Office of the President of the United States. The U.S. Census Bureau is responsible for implementing the National Census, which is a division of the Economic and Statistic Administration of the U.S. Department of Commerce, USDOC. The USDOC is a department of the executive branch, obviously. Census 2000 is authorized, carried out, controlled, enforced, and implemented by the President, the executive branch of the federal government, functioning as it has been since 1861 in the lawless realm of necessity, which is now even more degenerate than when it commenced under Lincoln. In fact, the executive office of the president controls the entire nation through various departments and agencies affecting justice, communication, health, energy, transportation, education, defense, treasury, labor, agriculture, mails, and much more, through a myriad of executive orders, proclamations, policies, and decisions. Every U.S. president since Lincoln has claimed his authority for these executive orders on Article 2, Section 2 of the Constitution of the United States of America, 1764 to date. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into actual service of the United States. He shall have power by and with the advice and consent of the Senate to make treaties, provided that 2/3 of the senators pre- present concur, and shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers as they think proper, in the President alone, in the courts of law, or in the heads of department. In reality, the Congress is completely bypassed since the Senate was convened in April 1861 by the Presidential Executive Order Number 2, not by lawful constitutional due process. There is no United States Congress. The current Senate and House are like everything color of Senate, under the direct authority of the executive office of the President. The President legally needs neither the consent nor a vote for the Senate, simply because the Senate's legal authority to meet exists only by executive order. Ambassador, public minister, counsel, federal judges, and all officers of the United States are appointed by and under the authority of the executive office of the President. So in other words, everything they're doing is by color of authority, color of law, color of office. Okay? Very important to understand that. The Federal Registry is an executive function. This first official act of every incoming president is to reaffirm the war powers. He must do so, or he is devoid of power to function in office. The war powers are set forth in the Trading with the Enemy Act of October 6, 1917, as amended March 9th, 1933, the Banking Relief Act. In the Amendatory Act, every citizen of the United States was made an enemy of the government, i.e., the Federal Reserve, IMF, International Monetary Fund, all creditors in bankruptcy who have conquered the country by their great paper money banking swindle and scheme. For the past 65 years, every presidential executive order has become purported law simply by its publication in the Federal Register. It's another thing that you guys need to become familiar with, the Federal Register, which is operated by the Office of the Federal Register, OFR. In 1935, the OFR was established by the Federal Register Act. Again, that happened in 1935, OFR, the Federal Register Act. The purported authority for the OFR is found within the United States Code under Title 44, Chapter 15, subsection 1506, Administrative Committee of the Federal Registrar, established and composition, powers, and duties. The Administrative Committee of the Federal Registrar shall consist of the Archivist of the United States or acting archivist, who shall be chairman and officer of the Department of Justice designated by the Attorney General, and the public printer or acting public printer. The director of the Federal Registrar shall act as secretary of the committee. The committee shall prescribe, with the approval of the president, regulations for carrying out this chapter. Notice that the entire administrative committee of the Federal Registrar is comprised of officers of the federal government who appoints all federal officers. The president does. Who appoints all president officers? The president does. This act also gives the president the authority to decree all the regulations to carry out the act. By this monopoly, the executive establishes, controls, regulates, and enforces the federal government without the need for any approval from the Senate or anyone else other than his undisclosed superiors. He operates without any accountability to the people at all. How can this be considered lawful? In 1917, President Woodrow Wilson couldn't persuade Congress to agree with his desire to arm the United States vessels traveling hostile German waters before the United States entered World War I. So Wilson simply invoked the policy through a presidential executive order. President Franklin Delano Roosevelt issued Order Number 9066 in December 1941, forcing 100,000 American Japanese descent to be rounded up and placed in concentration camps while all their property was confiscated. Is it any wonder what that the Congress with the president which the president legally controls, did not impeach President William Jefferson Clinton when the evidence for impeachment was overwhelming. On that note, why is it that attorney presidents have used executive orders the most? Who but an attorney would know and understand legal rules the best? Sadly, they enforce what's legal and ignore what's lawful. In fact, they have no access to what is lawful since the entirety of their authority, which is ethically and existently suspicious, derives from the war powers. How debt is assumed by legal fictions. We now refer back to the matter of assumption, as already discussed, with its relationship to arbitrarily created juristic persons, ergo, State of California, all capital letter name, or John P. Jones, all capital letters. Since an assumption, by definition, implies debt, what debt does a legal fiction assume? Now that we have explored the legal executive basis of the current federal and state governments, it's time to put all things together. The government uses the all caps in place of the proper name is absolutely no mistake. It signifies an internal legal rule and authority. Its foundation is pure artifice, and results have compounded into more deceit in the form of created, promulgated, instituted, administered, and enforced rules, codes, statutes, and policies, i.e., the laws that appear to be but are not, never were, and never can be. He who enjoys the benefit ought to also bear the burden. He who enjoys the advantage of a right takes the accompanying disadvantage. A privilege is subject to its condition or conditions. Bouvier's Maxims of Law, 1856. The birth certificate. Since the early 1960s, state governments themselves specially created juristic corporate persons signified by the all caps have issued birth certificates to persons with legal fictions all caps names. This is not a lawful record of your physical birth, but rather the birth of a juristic all caps name person. It may appear to be your true name, but since no proper name is ever written in all caps, either lawfully or grammatically, and remember there are laws to grammar, it does not identify who you are. The birth certificate is the government's self-created document of title for its new property, i.e., the deed of the juristic name artificial person whose all caps name mirrors your true name. The birth certificate brings the new all caps name into colorable admiral maritime law. The same way a ship and ship of state is birthed. And birth is B-E-R-T-H-E-D. Birthed. One important area to address before going any further is the governmental use of the older data storage from the late 1950s until the early 1980s as a leftover from various teletype-oriented systems. Many government data storage methods used all caps for proper names. The IRS was supposedly still complaining about some of their antiquated storage systems as recent as of the early 1980s. At first, this may have been a necessity of the technology at the time, not a deliberate act. Perhaps when this technology was first being used and implemented into the mainstream of communications, some legal experts saw it as a perfect tool for their perfidious intentions. What better excuse could there be? However, since local, state, and federal offices primarily used typewriters during that same time period, and birth certificates and other important documents such as driver's licenses were produced with typewriters, it's very doubtful that this possesses much of an excuse to explain all caps usage for proper names. The only reasonable usage of the older data bank all caps storage system would have been for addressing envelopes or certain forms in bulk, including payment checks, which the government did frequently. Automated computer systems with daisy wheel and pin printers used prevalently in the early 1980s emulated the IBM electric typewriter Courier or Helvetica fonts in both upper and lowercase letters. Shortly thereafter, the introduction of laser and inkjet printers with multiple fronts with multiple fonts became the standard. For the past 15 years, there is no excuse that the government computers will not accommodate the use of lowercase letters unless the older data is still stored in the original form, i.e., all caps, and has not been translated due to the cost of re-entry. But this does not excuse the entry of new data, only legacy data. In fact, on many government forms today, proper names are in all caps, while other areas of the same computer produced documents are in both upper and lowercase format. One can only conclude that now, more than ever, the use of all caps in substitution, the writing a proper name is no mistake. When a child is born, the hospital sends the original, not a copy, of the record of live birth to the State Bureau of Vital Statistics, sometimes called the Department of Health and Rehabilitative Service, HRS. Each state is required to supply the United States with the birth, death, and health statistics. The state agency that receives the original record of live birth keeps it and then issues a birth certificate in the corrupted all caps version of the baby's true name, i.e., James Wilbur Smith, all capital letters. Certificate, noun, Middle English, certificate, from Middle French, from medieval Latin, certificatum, from late Latin, neuter, or certificatus, past participle of certificate, to certify. 15th century. 3. A document evidencing ownership or debt. Merriam-Webster's Dictionary, 1998. The birth certificate issued by the state is then registered with the U.S. Department of Commerce, the executive office, especially through their own sub-agency, the U.S. Census Bureau, which is responsible to register vital statistics from all the states. The word registered, as it is used within commercial or legal-based equity law, does not mean that the all caps name was merely noted in a book for reference purposes. When a birth certificate is registered with the U.S. Department of Commerce, it means that the all caps legal person named thereon has become a surety or a guarantor, a condition and obligation that is automatically and unwittingly assumed unless you rebut the presumptions by effectively noticing them in "It Ain't Me." Registered security, bond, Merriam-Webster's Dictionary of Law, 1996. Security. 1. A. Something as a mortgage or collateral that is provided to make certain that fulfillment of an obligation. Example, use his property as security for a loan. Surety. Evidence of indebtedness, ownership, or the right to ownership. Bond 1. A. A usually formal written agreement by which a person undertakes to perform a certain act, as fulfill the obligation of contract, with the condition that failure to perform or abstain will obligate the person to pay a sum of money or will result in the forfeiture of money put up by the person or surety. 1b. One who acts as surety. An interest-bearing document giving evidence of a debt issued by a government body or corporation that is sometimes secured by a lien on property and is often designed to take care of a particular financial need. I bid. Surety, the person who has pledged himself or herself to pay back money or perform a certain action if the principal to a contract fails. As collateral and as part of the original contract, Duheim's Law Dictionary. 1. A formal engagement as a pledge given for the fulfillment of an undertaking. 2. One who promises to answer for the debt or default of another. Under the Uniform Commercial Code, however, a surety includes a guarantor and The two terms are generally interchangeable. Merriam-Webster's Dictionary of Law, 1996. Guarantor, a person who pledges collateral for the contract of another, but separately, as part of the independently contract with the obligee of the original contract. Duheim's Law Dictionary. It is not difficult to see that the state-created birth certificate with an all-caps name is a document evidencing debt the moment that it is issued. Once a state has registered a birth document with the U.S. Department of Commerce, the Department of Commerce notifies the Treasury Department, which takes out a loan from the Federal Reserve. The Treasury uses the loan to purchase a bond. The Fed holds a purchase money security interest in the bond from the Department of Commerce, which invests the sale proceeds into the stock or bond market. The Treasury Department then issues Treasury securities in the form of Treasury bonds, notes, and bills, using the bonds as surety for the new securities. This cycle is based on the future tax revenues of the legal person whose name appears on the birth certificate. This also means that a bankrupt corporate U.S. can guarantee to the purchaser of their securities the lifetime labor and tax revenues of every citizen of the United States American with a birth certificate as collateral for payment. This device is initiated simply by converting the lawful true name of the child into a legal juristic name of a person. The principal part of everything is in the beginning. Well begun is half done. Legally, you are considered to be a slave or indentured servant to the various federal, state, and local governments via the Department of Health owned, state issued, and state created birth certificate in the name of your all caps person. Birth certificates are issued so that the issuer can claim exclusive title to the legal person created thereby. This is further compounded when one voluntarily obtains a driver's license, a social security account number. The state even owns your personal and private life through your state-issued marriage license certificate issued in the all-caps name. You have no right in birth, marriage, or even death. The state holds the title to all legal persons the state creates via birth certificates until the rightful owner, i.e. you, reclaims, redeems it by becoming the holder in due course of the instrument. The main problem is that the mother and father and then the 18-year-old man or woman voluntarily agree to this contrived system of plunder and slavery by remaining silent. A legal default, latches, and failing to claim one's own rights, the maximum of law becomes crucially operative. He who fails to assert his rights has none. The legal rules and codes enforce themselves. There is no court hearing to determine if those rules are correct. Government rules are self-regulating and self-supporting. Once set into motion, such laws automatically come into effect, provided the legal process has been followed. The various bankruptcies. The juristic, legal person known as the United States is bankrupt and withholds all lawful and constitutionally mandated silver and gold coins and bullion, with which to back any currency. All privately held and federally held gold coins and bullion in America was seized via executive order of April 5th, 1933, and April 5th, 1933, and paid to the creditor, the private Federal Reserve Corporation, under the terms of the bankruptcy. Congress, still convening strictly under executive order authority, confirmed the bankruptcy through the joint resolution to suspend the gold standard and abrogate the gold clause, June 5th and 6th, 1933, House Resolution of June 5th and June 6th, 1933, 73rd Congress, First Session, Public Law 7310. This 1933 public law states, in part, every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency or in an amount in money of the United States measured thereby is declared to be against public policy. This is a very, very, very important key point, ladies and gentlemen, when challenging mortgages and everything else, alleged indebtedness and things of that nature. Okay. This is what I call foundational. The corporate U.S. declared bankruptcy a second time, whereby the Secretary of Treasury was appointed receiver, another important word, receiver for the bankrupt U.S. in Reorganization Plan Number 26, Title 5, United States Code 903, Public Law 94-564, Legislative History, page 5967. Since 1933, the only assets used by the United States to pay its debts to the Fed have been the blood, sweat, and tears of every American unfortunate to be saddled with a birth certificate and a Social Security account number. The U.S. government must conceal this fact from the American people at all cost. Their future labor and tax revenues have been legally pledged via the new all-caps juristic person names appearing on the birth certificate, i.e. the securities used as collateral for loans of credit, thin air belief, to pay daily operational cost, reorganization expenses in bankruptcy, insurance policies, premiums required to float the bankrupt government, and interest on the ever-increasing, wholly fraudulent debt. All caps legal person versus the lawful being. Just who or what is the all caps person, i.e., John Paul Jones, the all caps name, or John P. Jones, the all caps name, or some other all caps letter corruption thereof in variation? It is the entity the government created to take the place of the real being, i.e., John Paul Jones, uppercase, lowercase, Christian proper appellation. The lawful Christian name of birthright has been replaced with a legal corporate name of deceit and fraud. If the lawful Christian name answers as the legal person, the two are recognized as being one and the same under the doctrine of idiom sonum. However, if the lawful being distinguishes himself or herself as a party other than the legal fiction, the two are separated. As a result of federal bankruptcy was the creation of the United States all capital letters corporation, which was made a part of the legal reorganization. The name of each state, all capital letters, was also converted to its respective all caps juristic legal person, ergo state of Delaware. These new juristic legal persons were then used to create more legal persons such as corporations with all capital letter names as well. Once this was accomplished, the greed quickly picked up speed. All areas of government and all alleged courts of law are de facto, color of law, and right institutions. The Circuit Court of Wayne County in all capital letters and the U.S. District Court, all capital letters, can recognize and deal only with other legal persons. This is why a lawful name is never entered in their records. The all caps juristic legal person is used instead. Jurisdiction in such sham courts covers only other artificial persons. The proper jurisdiction for a lawful being is a constitutionally sanctioned common law venue court. Unfortunately, such jurisdiction was shelved in 1938 with the passage of Erie Railroad versus Tompkins. Of course, I'm ad-libbing here because there are things that are missing that are certainly important for you to grasp the concept of what is transpiring. In 1938, and is no longer available to most. Most all courts today are statutorily commercial tribunals collecting tribute plunder from the alleged creditors who think they have conquered the country on their way to ruling the world. The Organic versus Corporate United States of America. 1871 District of Columbia Organic Act, the franchises of corporate America, the 14th Amendment citizen, the newly created corporate you, all caps letters, how you have become the surety, the corporation doing business together, how it works and is enforced. You have the Real de jure America project and to protect and serve, followed by the corporate vital statistics business. Then it transformed over through the corporate you juristic person, for profit and in persons, and it relates back to the sovereign rule of self. So it's a vicious circle here. And in order to capitalize on it, for a lack of a better term, we need to have a firm understanding of how it works. You don't have to like the system. The system doesn't care about your emotions. It's okay to be upset. It's okay to be angry. It's all right to be mad. But I'm telling you, the system doesn't care about your feelings. Think of it as a computer chipboard. Everything has a function, and if you don't enter the right sequences in, the function that you so seek and desire cannot be obtained. Okay, so I want you guys to start looking at this in a different light. All right, because through comprehension and understanding does come the enjoyment of life, liberty, pursuit of happiness, and the enjoyment of property. Okay, and so it's just a matter of comprehending, and everybody's going to go through a phase of the 7 stages of denial, anger, resentment, feeling like you've been lied to, and it's okay to have those emotions, all right? But eventually you need to set aside those emotions because the system doesn't respond to emotion, okay? It responds to very cold and calculated and precise commands. And that's what I'm here to do, is help you learn how to assert yourself in a positive manner that is well received within the system, because if the proper cues are entered in, they have no choice but to agree. All right, because it's not an emotional thing. All right, it's a systematic thing. It's a schematic. It's a blueprint. It's a drawing. And if you don't enter in things proper, then you will not get the result that you seek. All right. So with that, I'm going to finish with this last paragraph, and we'll come back for section number 3. Now, to bring this section home, I would like for you to see this this court case. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. Okay? So separating fiction from reality is your objective, no matter how painful it may be. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate, artificial persons, and contracts between them. So when you believe that you're being summoned into a court, understand you are not the thing, the res, the in rem that they are administering. Okay? And it may take you some time. Some people pick this up 6 weeks. Other people will spend a lifetime trying to wrap their head around it and never succeed. So do not base your success predicated on other people's achievements of their milestones. Okay? It's okay to acknowledge it. It's okay to see what they've done. But in order for you to succeed and enjoy this, you need to stay focused. And focusing on what other people have achieved and how they achieved it isn't necessarily the proper way to find fulfillment. All right? Penhollow versus Doan's administration. So with that, we'll talk to you guys here in a little bit. I'm going to try and keep these in 1 hour segments. We're at 1 hour and 7 minutes. Thanks for all your support. Thanks for lending me your time. And I hope this starts to begin to help you. Again, this is the Ucc And You first edition. For those of you that are wanting to know what we're digesting here, I would encourage all of you to go download it, and you can read along with me. Some people have reading comprehension problems. Some people are visual audio learners. Other people want to be told what to do. I'm going to tell you right now, if you're looking to be told what to do, I'm not your guy. This is something that you're going to have to learn and apply on your own. Remember, every time that failure presents itself, failure is part of success. If you don't fucking embrace that failure, I'm telling you right now, and acknowledge what is wrong within your process, forms, documents, and what you're trying to articulate in order to obtain your goals or achieve what you set out to achieve. All right, you will continually make the same mistakes. Thank you for joining me. We'll see you soon.